Hello everyone, welcome back again to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. Maritime law policy analysis regarding illegal fishing activities in Indonesian waters. Indonesia is a country that has great potential in the marine and fisheries sector. This country, which has around 16,056 islands, has a comparative advantage in the maritime sector that can be utilized by all parties to achieve optimum welfare from the government, private sector, to local communities. The Ministry of Maritime Affairs and Fisheries 2017 explained that the potential of Indonesia's marine research, especially the fishery sector, reached 12.54 million tons per year. In addition, Indonesia's comparative advantage in the maritime sector also has significant economic implications. So far, the economic potential of the marine sector can reach 1.38 trillion US dollar. The national So far, the economic potential of the marine sector can reach 1.38 trillion US dollar per year, or 1.3 times the 2019 national gross domestic product, and is able to create 45 million jobs. Central Bureau of Statistics 2019 showed that the contribution of fishery gross domestic product to national gross domestic product has always increased in the last 6 years. In 2019, the value of fisheries gross domestic product reached 347 trillion rupees and contributed around 2.62%. This indicates that the potential of marine research in Indonesia is very large to be optimized. However, the condition of Indonesia's marine research still face various problems, such as the addition of the volume of plastic waste, pollution of coral reef and mangrove ecosystem, illegal fishing and overfishing practices, and inadequate basic infrastructure. Focusing on illegal fishing activities in Indonesia, the Ministry of Maritime Affairs and Fisheries noted that from 2016 until 2019, there were around 163 illegal vessels that were proven to be legally catching wild fish in Indonesian waters, such as on the Natuna border. Referring to the regulation of Minister of Marine Affairs and Fisheries of the Republic of Indonesia, number 37, Permen KP 2017, illegal fishing is an illegal fishing activity or activity fisheries that are carried out contrary to the provisions of the legislation in the field of fisheries. So far, Indonesia has suffered losses of more than 100 trillion due to illegal fishing activities, and the potential loss of state revenue reached 5 billion US dollar per year. It is estimated that every year around 3,160 foreign fishing vessels operate illegally in Indonesian waters. This phenomenon strongly reinforces the assumption that Indonesia is a safe home for perpetrators of illegal fishing from several neighboring countries such as Vietnam, Philippines, Thailand, and other sub-living countries. In the process, fish theft was carried out by several foreign ships that infiltrated Indonesian waters. After entering Indonesian waters, the ship can carry out fishing theft. In its implementation, illegal fishing is usually done in border areas such as waters of Maluku, Sulawesi, and Kalimantan. These areas are directly adjacent to several neighbors, such as Philippines and South China Sea, are classified as vulnerable. From a legal perspective, Indonesia is a country that implements aspects of the maritime law. From a global point of view, the 1982 Law of the Sea Convention states that a coastal state has the right to manage all forms of fishery resources, in its territorial sea up to its exclusive economic zone. From a national point of view, Law number 45 of 2009 concerning amendments to Law number 31 of 2014 concerning fisheries is very vital with the vast waters of Indonesia, which includes water of national sovereignty and jurisdictions. Implementation of Law number 45 of 2009 is also a strategic policy and becomes the basis for law enforcers and fisheries judges in deciding legal issues related to illegal fishing, which has negative implications for the country's economy. To overcome this, Indonesia has various structural problems in the maritime sector, such as overlapping regional governance, synchronization of regional policies, low quality of law enforcement, inefficiency of the licensing system, weak institutional quality, lack of quality, lack of quality human research in maritime law enforcement, and inadequate marine facilities and infrastructure. Law of the Republic of Indonesia number 45 of 2009 on the amendment to Law of the Republic of Indonesia number 31 of 2004 concerning fisheries as contained regulation but regarding criminal procedural law and fisheries criminal acts. State institutions authorized to carry out investigation, prosecutions, and adjudicate criminal acts of illegal fishing include the Ministry of Marine Affairs and Fisheries, the Navy, the Indonesian National Police, the Attorney General Office, and the Fisheries Court or District Court. In the trial process, the Fisheries Court is led by career judge as chairman of the panel and two members from ad hoc judges as regulated in Article 78, Paragraph 1 of Law number 45 of 2009 on the amendment of Law number 31 of 2004 concerning fisheries. Procedural law, the Criminal Act of Illegal Fishing, used the law of the brief examination procedure. This is seen from the process of investigating, prosecuting, and adjudicating the Criminal Act of Illegal Fishing, which is shorter than the ordinary criminal law process described in Article 73, Paragraph 6, Article 73, Paragraph 7, Article 76, Paragraph 5, Article 76, Paragraph 6, Article 81, Article 82, and Article 83 of the Law of the Republic of Indonesia number 45 of the 2009 on the amendment of Law number 31 of 2004 concerning fishery. Furthermore, the fisheries law has also regulated supervision related to the prosecution of illegal ships activities in Indonesia, where Article 69, Paragraph 1 of Law number 31 of 2004 regarding fisheries, it has been determined that fisheries supervisory vessels have the function of carrying out supervisions and law enforcement in the field of fisheries within the fishery management area of the Republic of Indonesia. Whereas Article 96, Paragraph 4 reads, in carrying out the function as referred to in Paragraph 1, fishery investigator and or supervisor may take special action in the form of burning and or skinning foreign flag fishing vessels based on sufficient preliminary evidence. Furthermore, the act of extermination refers to the provision of Article 76, letter A of the Fisheries Law that objects or tools used or produced or produced from fisheries crime can be confiscated or destroyed after obtaining court approval. Looking at the juridical review and the legal basis, the prosecution of illegal fishing activities is legal in Indonesia. Okay everyone, that's all this article today. Thank you so much for watching. Until the next one. Bye bye.